Greetings, pairs, orphans, and retrogrades. Big news this week out of the Supreme Court. As you well know, it looks by leaked draft opinion anyway, that Roe versus Wade is to be overturned in the release of the official holding of Dobbs versus Jackson Women's Health next month. There's been tons of fallout on this, tons of commentary. I think most of the commentary has been very underwhelming. Not here on Rules for Retrogrades. Today I have two extremely distinguished guests, and I'm also proud to say, I'm bragging a little bit, friends of the program. And I'm going to introduce both of them to you right now. The first is, because his name came up first on my bio here, John Czarnetzky, who is the Chief Executive Officer and Dean of Ave Maria Law. John Czarnetzky is a graduate of MIT and the University of Virginia School of Law. I also have for you Ronald J. Rychlak, who is a distinguished professor of law at the University of Mississippi School of Law and is holder of the Jamie L. Whitten Chair in Law and Government. And Ron and I have even gotten together and had a bite here in Hattiesburg. I'm truly pleased to have both of these gents on, and you guys are friends. We're free to mix it up now. Thank you for coming on with me.
It's a real pleasure, Tim.
Happy to be here.
Okay.
Well, I was at the University of Mississippi for 27 years. So yes, Ron and I know each other pretty well.
You guys are homeboys. Yeah, that's we were kind of all talking when me and Ron got a bite to eat here in Hattiesburg. You were texting and we were sending messages, and we have a little, I think we've had a little group text before. So when stuff like this happens, for one thing, it's a bit of a muscle for me that I don't get to flex too often doing what I do now, which is usually current events in the Catholic Church. Dobbs versus Jackson Women's Health is a bit of, it's an excellent thing in about two ways that we're going to talk about here today, from my perspective: abortion, blue state, red state, but also a third way, because it gives me the opportunity to talk. My other passion besides Aristotelism is constitutional law, particularly constitutional law where we get to beat up on the 14th Amendment. That's my other passion. And so it's important, because what essentially we're speculating is going to happen next month, I'll throw this first one to you, John, is an overturn of Roe versus Wade. And I guess this is really the second main thing I wanted to talk about, but introductorily, it gives the issue back to the states, and everyone's talking about it. First off, I mean, do you think blue staters are going to revolt or to leave, as they're threatening to do? There's a planned assault on Sunday masses everywhere by these blue-haired freaks, blue stater, blue-haired freaks on Sunday. What do you think they're going to do, and why?
Well, I think it's a mistake to underestimate the vehemence of the reaction that we will see. I certainly hope that there won't be disruptions of Catholic masses, but would it shock me? No. I hate the thought that this will lead to violence. It's ironic that a decision stopping the aborting, the killing of babies, is going to lead to violence in Catholic masses. I'm afraid that I am worried about it, but I also have a lot of confidence in faithful Catholics that we will respond in the great tradition of our church and of Christianity, that we should not meet violence with violence unless it's a matter of self-protection. So it's not a very profound statement. I'm not very good prognosticator about social things. I'm constantly surprised, usually on the low end of things, unfortunately. So I think, Tim, on your broader issue of sending things back to the states, I've done a couple interviews with folks in Catholic media. And one thing that folks haven't thought through, I think, is throwing this back to the states does not spell the end of the pro-life movement. We're going to have to roll up our sleeves and multiply our efforts times 50 or 30 or whatever number of states where there is still going to be work done. I'm sure you saw Gavin Newsom talking about all the things he's going to do in your former home state.
Yes.
There's, if anything, a lot more work to be done and less centralized. So I think that's one thing that maybe in celebrating, and it's also premature to celebrate until the decision is handed down officially by the court. We saw with the Obamacare decision several years ago that draft opinions can sometimes turn into dissents because votes change before the final decision's handed down. So there's a, yes, it's worth celebrating. It's certainly worth discussing, but there's more work to be done, even if this ends up being the decision of the court.
You're referring to Obergefell, right?
Yes, yes.
Yeah. Yeah, people forget about Obergefell and old Chief Justice John Roberts, who changed his position 2 nights before the holding, was it?
And then to go back to your con law class, going back to law school, as I am in my mind, remember the old a switch in time saved 9, where Franklin Roosevelt, I forget which case it was, did some jawboning directed to the Supreme Court when they started holding that aspects of the New Deal were unconstitutional. There was jawboning about packing the court back then, and then magically votes changed in subsequent cases, and that's known as a switch in time saved 9 that ended the original court packing scheme. So it's not unprecedented. We need to be, yes, celebrate, but approach with humility and really back those justices that it looks like are on joining Justice Alito.
That was just a coincidence, John. I'm the one man in the world that believes that was just a coincidence. I'm joking.
Oh, I've forgotten that from your book. I'm sorry.
Yeah. No, it really wasn't, guys. The switch in time that saved 9 was leftist, communist, FDR-style threats landing. That's indeed what it was, and it's something that Biden and the Dem crew in Congress have taken up. But okay, back to whether or not blue states will revolt or leave. It's going to be a theme that we recur to in both the second and the third topics that I have you for today. Ron, shouldn't we're all here in the South. Shouldn't we, the red staters, just grant blue staters this no-fault divorce? We were talking about metaphorical divorce before we rolled tape, and should we just grant them this? You know, what are leftists always saying? It's for the kids. Mommy and daddy don't love one another anymore, but we still care about the kids, you know, the progeny. It would be best to just leave well enough alone and have a peaceable divorce, the way they're always propagandizing us with, that there's such a thing as peaceable divorce between a man and a wife. Well, there's not. That is war on the civil society, divorce, the very proposition of divorce between man and woman. But I'm very pro-divorce, peaceable divorce, no fault divorce even, when it comes to red and blue staters. There is no love between daddy and mommy anymore. We are daddy, they are mommy.
Well, Tim, you know, the South tried to divorce once. It didn't go so well. When push came to shove, they didn't really sign the documents. So I think we got to be careful about thinking of actually breaking up the nation. I do think there's a divide, but you know, I mean, look, I'm from the Midwest. There's an awful lot of really good people, and John and I spent a lot of time up in New York. And working for the Holy See at the United Nations. Awful lot of good people throughout the country, and the majority, the big cities are where we see the real problem. I mean, you look at a map of votes, and you know that's where you're going to see the blue is on the big cities, and so there's that divide almost more than states in some ways. As you were talking, as John was talking in particular. I was thinking about New York because John and I became pretty good friends with Father Newhouse, who's passed away now, but he used to run the First Things journal, which was brilliant. And he did some hosting on EWTN and such. I remember talking about protests at churches, and sort of saying that everybody always complains. And he's like, yeah, because they recognize it's the Catholic Church that stands on the other side. They protest to Rome, or they protest at St. Patrick's in New York. They recognize that we are the people standing up for traditional marriage, for children, for traditional rights. And that's why you sometimes may feel put upon as a Catholic, but being the focus of hate from the other side says that you're in the right place.
Agreed. It shows we're over the target. It also shows even the secularists understand that we are the one true church, the one true faith, in their visceral, animal way. I mean, like I think Oliver Wendell Holmes said, even a dog understands the difference between being kicked and being tripped over. Since we're legal panel today, we should be quoting Holmes. But okay, here's the thing. I want to push back, and I'll go back to John on this.
Yeah.
Oh, by the way, that first case in 1937, reflecting the court's coincidental new attitude, the first appearance thereof was West Coast Hotel v. Parrish. By the way,
Thank you. Yes.
For the legal trivials out there, I had to look it up. In Kevin R.C. Gutzman's excellent book.
You're going back to your law school books now, bringing them back in the middle of the interview. I don't know if that's fair. It's
yeah. Well, the politically incorrect guide, just so you know, to the Constitution is a Regnery book. Regnery is a great
publishing company.
Great publisher. Yeah.
Excellent. Greatest secular conservative book publisher in the world, and literally the best and the biggest. But I took 9 courses on the Constitution or jurisprudence in law school at USD, at the Center for Originalism there. I had no interest in practicing law, which I've told people before, because I was coming from doing a PhD in philosophy in Rome, and I just had no interest in anything but theory. And con law is the most flexed muscle in terms of philosophical jurisprudential theory. And here's the thing. I don't want to just gloss past it. I don't want to. You guys sound like you might disagree, but when it comes to red state, blue state, this is going to move us in a second on to Hadley Archie's piece on Catholic Thing 2 days ago. But I don't want to just rush past the mommy daddy divorce issue between red and blue state. There is truly, in the truest sense, from Aristotle and Plato through Boethius and St. Augustine, through the early Middle Ages up to Bellarmine and Thomas, then late Middle Ages, Suarez, Mariana, the other Salamancans, right through Pio Nono, Pope Pius IX, who actually supported Jefferson Davis, and then through Pius X and especially Pius XI in Quadragesimo Anno. There is a strong tradition, of subsidiarity. It doesn't matter what type of regime you have. There are 3 good regimes that the Catholic Church has always endorsed. A republic is one of them. They all have a perverted form. We're definitely in the perverted form of republic now. But all of these Catholic and proto-Catholic thinkers, if you include Plato and Aristotle, include in their republican theory, it must be subsidiarian. You have to have local power. It's the equivalent of a collective mortal sin, says Pius XI, to not have subsidiarity in the republic. And you have to, for each of these, the central thing in a republic has to be a res publica. And the res publica says all of these thinkers, plus let's even toss in Montesquieu, who was a lapsed Catholic, who returned to the faith on his deathbed. You have to have a res publica. And Augustine writes more than anyone on this. There is simply no res publica shared between red staters and blue staters. Montesquieu says, look, there are 3 cardinal rules for republics. One was basically about, there shouldn't be shared powers between the 3 branches. We won't talk about that. But there are 2 rules of these 3 cardinal rules that Montesquieu has that if he's right, it means we should definitely get a divorce. And I take him to be right. First rule is republics must be small. I mean, the size of one of our smallest states. There is no historical precedent, John, for a continent-sized republic, which is the United States takes up 60% of the population of North America. Ridiculous. So a continent-sized republic is a contradiction in terms. We're talking about historical instances: Little Malta, the island of England, the Swiss cantons, the Venetian island. These are the most successful 1,000-year republics on the globe before they became corrupted and died. And yet we've had this, a quarter of that time run in the sun. It's because we tried to make a continent-sized republic, which is a contradiction in terms. And the second rule is, well, if you try to be big, like any club, a res publica is a club, then you can't keep the ideological boundaries straight. You can't keep the ideology pure. A res publica should not have ideological diversity. Ethnic diversity is another thing, but ideological diversity, no. It needs to have a res publica. This is Montesquieu's second rule. Everyone needs to have the same morality and religion, or else there is no res publica. So if I'm assuming that both of you guys are going to politely or gently push back on me, then we are saying Montesquieu is wrong. And I think he's right. But just to be clear, it's either Montesquieu and the whole Republican tradition, including Aquinas and Aristotle and all the other smarty pantses you don't want to run foul of, generally speaking. They either got it wrong or we're just not a republic. And also the other thing is 1776. This stands for the proposition that it wasn't a one-time deal. Now, I'm not suggesting violence. I'm suggesting a no-fault divorce. The blue states are going to want to leave next month. And I say, bye-bye, like Damian Lillard waving to Russell Westbrook 3 years ago in the playoffs after he hit that three. What do you say, John? And then what will you say, Ron, after that?
Well, boy, Tim, you threw a lot out there, and I certainly do not pretend to be a philosopher. I'm a lawyer that reads books. But I guess I think that the problem is, and you touched on this, a lack of a shared, shall we say, morality or governing ethos. What's happened, I'll just give you my reaction to what you said. What's happened in our country is a loss of, in the culture, a common background to our law. So what is Aquinas's definition of law? An ordinance of reason promulgated by the proper authority that serves the common good. Well, we Americans in 2022 won't even talk about what is the good. The highest value seems to be freedom. I'm free. Well, freedom is a tool to serve the good and the true and the beautiful. Freedom is not an absolute value in and of itself. And yet it seems to, this is John Czarnetzky's great theory of American political philosophy. Freedom has come to be the only good in our society. And that is devastating. We're reaping the whirlwind of that devastating fact in our society. But also it gives me hope. We see the devastation. Perhaps, Tim, this rejection of Roe versus Wade will lead to us recapturing some type of common ethos. I know that makes me sound like a wide-eyed idealist, but I'm not. Let me back up and just answer you directly. I'm not ready to declare divorce yet, because and Ron will tell you, I'm generally a pessimist about human nature, very much so. But I'm not a pessimist about the truth. The truth always wins in the end. It may take more than our lifetime, but I have friends, very smart friends that I love, who have been saying to me, why do you care about Supreme Court justices and politicians, what they say about abortion? That's never going to change. Well, you know what? I've lived to see it. We're on the cusp of it changing. And that's because I believe truth wins out in the end. So my response to what you said is, I still have hopes for our culture, even as degraded as it seems to be now. I know that doesn't directly answer your philosophical point, but that's my reaction to what you said.
No, that's a very direct answer. I appreciate it, John. But here, so in repitching this to Ron, I would just say this, and then John, maybe after that, you could say whether you agree or disagree. I think that freedom, undirected freedom, which is actually license. This is pointed out by Hattiesburg in his article I'm about to reference when we go on to the related next topic, is license versus liberty. Generally speaking, secular humanists call license liberty, but what they mean is license. Non-ordered freedom is license, freedom for its own sake. Ordered freedom is liberty. Thomists and Catholics in general understand the distinction quite well. I think blue staters, I'm still insisting on this distinction, generally speaking, doesn't mean that there aren't conservatives in the blue states or vice versa, but generally speaking, blue staters and blue states represent the proposition that, that John just expressed, that license actually is the highest good, and they call it liberty. They dress it up as liberty, maybe the only political good. That's what Roe versus Wade stands for. But in the red states here, where I met you guys, Mississippi, you're both of your home state, as far as I know, Mississippi, that's not true. My neighbors in this neighborhood drive around golf carts just for fun around the neighborhood with their kids. They're talking. A lot of them still have Trump flags up. They all of them are wearing like Jesus shirts. Of course, they're Baptists, but they love Jesus, and they love God. They love the cross. They love country, and they love their families. And they understand that liberty is ordered at serving these things. And they love the good. It's ordered at serving these four things: God, country, family, the good. So, and I think they're pretty, I'm generalizing a bit, but you have to generalize some. I think, Ron, it's pretty safe to say these folks are the norm in red states. Exception makes bad law. Yes, there are weirdos that live here that try to harass us, but just as there are good people in blue states, but let's deal with norms. I don't think freedom is the only thing that is honored now around the whole country. I think it is honored in the blue states, where all of the institutions of culture, mainly media, are made. But red staters, we still have it. And I don't think there's any serious reconnection that would need to happen. Let's just indulge me for a second. I was looking at that Roe map that my wife was talking about and showing people. All the trigger states and the likely states that would join the trigger states if this Dobbs decision goes through next month, immediately abortion will be unavailable. That map pretty much represents the good guys in the country. I'd get it up for you, but I can only do the graphics when it's one-on-one interviews. So, I mean, that wouldn't be a lot of conversion if all of a sudden we're just free of the dead weight of the blue states. To me, it feels like some sort of almost re-Edenic dream. What do you say? I mean, can't we indulge the fantasy a little bit? The red states without the blue states, America would be great again, I say.
Well, look, I mean, there are some things that would probably benefit both sides. I mean, you came here from California, and I get but you travel California and you get away from the big cities, you take a train up and down and you see the farmlands and stuff. There's much value in a lot of those states. So the thing that people are overlooking, assuming the case comes down the way everyone looks like it will, is this is a tremendous return of liberty to the citizens. This is the ability, what we've had so far, according to the Supreme Court, the Constitution has blocked states from being able to protect unborn children. And you're both Whoopi Goldberg and President Biden referring to children now instead of plump cells. But that has prevented us from doing it when we wanted to. If this by itself, and this is going to, I think, lead to maybe your second topic, but by itself, all this case does is say, hey, Mississippi, you want to protect unborn children, you can. It doesn't really, it turns power back to the people. And you're talking about subsidiarity earlier, by the way. John and I have published several articles together. I think our first one was actually on subsidiarity at the international level, and our best placed piece was actually in the Notre Dame Law Review on subsidiarity. And because what the international order is trying to establish is an international global legal, John dubbed it an empire of law, where they construct the whole world and enforce it with things like the International Criminal Court, which John and I were among the earlier critics of it. It's having serious problems that we predicted 15 years ago. But I do think this return to the ability of locals to make more decisions, to decide, state by state, maybe avoids the necessity of a divorce that you're talking about, because we can once again protect our children. We would like the blue states to protect their children too, and that's going to be the next step. But at least removing the impediment that stops us from protecting our unborn children, this will be a huge thing if it comes down the way it looks.
And Tim, can I just add one quick thing? I'm a third order Dominican, and I may be the only law school dean that is, I'm not sure. But you used some interesting words. You talked about conversion. Just to think about the church's history, it sure would have been easier with the Albigensian heresy and the Arianism. It would have been easy for the true Christians to say, we're better off without those guys. And it's almost the Benedict option that's been talked about so much. Let's retreat into our communities, and we'll preserve the faith, and we'll move forward with the truth, and we're better off without them. But that was not St. Dominic's solution. He went out with just a few people, and he converted all of those people in southern France. Just a plug for my law school, I hope you won't mind. Ave Maria Law School is a faithful, truly Catholic school. And our entire mission is to train students in the truth about the human person, and at the same time teach them law. So we're giving them, it's like, as we've been talking about, we're giving them the tool, a law license. You know how valuable that is in society, but we're also teaching them how to use that tool properly. I think that's the solution to our cultural crisis. Liberty, law licenses, all these tools God gave us must be used properly for the good, the true, and the beautiful. And so we're producing 120 lawyers a year. That is, I believe, enough. We need 100 times that many, but that's enough to be the leaven in our society to go out there and start changing institutions and culture. Now, that makes me a wild-eyed idealist, I think, but I have enough faith in the truth, as I said earlier, that I think that's the solution. We need to go out and change the culture. Anyway, sorry, I'm on my soapbox a little bit.
No, that's beautiful. And Ave Maria Law is an excellent place. I nearly went there. They offered me a scholarship. I'd also visited the theology doctoral program. I'm forgetting in what order, but I very nearly went there. It was right when Abby was 6 months, and we'd just gotten back in the States and gotten set up with insurance for all of our many brain surgeries. But I nearly went there. It's a beautiful school, and it is one of a kind, Ave Maria Law, in terms of sorry, Ron. I'm sure you agree, though, Ron.
I've been on their board of directors for 10 years. So
yeah, okay. So you're happy. Yeah.
I love Ole Miss. I'm very and they're different experiences, but I'm behind Ave as well.
Right. No, I knew you guys were both Ave guys. It's just the holism of the formation of young lawyers is unbelievable. Now, I ended up staying in California, going to USD, which is far and away the best option for someone, right, for a Catholic. Yeah, because they're obsessed with Scott Rappaport and his Originalism Society. I met Scalia twice in very, very close quarters twice. He loves that. He loved that law school. And also it's got the law and philosophy program, and it's a place where you can take 9 constitutional courses, but it didn't have the formation of attorneys in the faith, even though it's technically a Catholic school that Ave Maria does. So that I don't think that starry-eyed optimism at all. I'm just saying, okay, so now this will get us on to Hadley Archie's article called "On the Consummate Statecraft of Samuel Alito." Appeared in the Catholic Thing on May the 4th, 2 days ago. And, where Archies, who was the co-drafter of, he's a hero for the anti-abortion movement in many ways. He's the co-drafter of the Born Alive legislation of 06 or 08. Remember, Obama wanted to, in Illinois, be able to kill babies that were born alive who survived abortion. Archies wrote the original template for that legislation. He's a good man, but now he reports that he, quote, fell into a mild despair in this article on the Catholic Thing when he read Alito's opinion. He called it statecraft, which is one of these Straussian terms. A lot of these guys are Straussians. So does Alito underwhelm by giving this issue back to the states? See, I say no, and this ends up being a tremendous 14th Amendment and federalism question. What do each of you gents say? John, what do you say first, then Ron?
Well, I say no, Tim. You and I have not discussed why you say no, but I say no because, first of all, Justice Alito is candid, very candid, in saying in the opinion forthrightly what any person speaking in good faith about Roe versus Wade for the past 20 years has said what Justice Alito has the guts to say in this draft opinion, which is Roe versus Wade was wrong from the start. It's a poor opinion. It is a blot on our constitutional system because it's poorly crafted. It's not well reasoned. That is a huge thing. It is a huge corrective. We should demand nothing short of excellence in the reasoning and opinions of the Supreme Court, and agree or disagree with them. Usually they do have a very high level of excellence. Roe versus Wade and another handful of famous decisions in the court's history, most of which have been repudiated over time, is an example of a very poor opinion. So just for that reason alone, it is a tremendous contribution by Justice Alito. Now you're asking a broader philosophical point. I'll let Ron take that one.
All right. I'm just following up what John said. I remember Vanderbilt University School of Law. My constitutional law professor is Tom McCoy, and he called it a horse manure, basically, the logic behind it. And as a law student, I thought if you wanted an outcome determinative opinion that came to that conclusion, there were better ways even to have gotten there. If you invoked doctrines like quickening and things like that, you could have at least built upon a true legal argument that really has never been there with Roe versus Wade. Roe versus Wade, people defended it because those people liked the outcome that it provided. So this Alito opinion appears to completely undercut that, I think, in a very valid way. The question, going back to more what Tim asked, I guess, or that Hadley Archis in his article brought. Hadley, by the way, has a chapter in a book that I edited that John wrote a chapter in as well. So we've known him for a while. He's a brilliant guy. I take it he's argued in essence that we should have gone further and said that through the 14th Amendment, we provide a right to life to unborn, and that unborn life needs to be protected. I've long thought that was a viable argument. This doesn't go that far. This is an enormous step in and of itself, though. This allows, as I said earlier, this allows states to protect children, which the Constitution, as interpreted by the Supreme Court, up until now has prevented states like Florida and Mississippi and Louisiana from being able to protect unborn children even when they wanted to. And that, to me, has been a terrible stain on the Constitution, akin to others. I mean, the Dred Scott opinion, internment of Japanese during World War II, the separate but equal.
Or Matsu, yeah.
Yeah, the separate. Well, I was trying to just name the issues so people who aren't lawyers, but you know, the Supreme Court has overturned some significant bad decisions in the past, and I think this is one of those.
I agreed. I agree with both of you, and I also agree with you that Arcus, I've read him in Claremont Review of Books for many years, and I admire him much. Is a very bright man, but he says a few things, okay, that I do take issue with, and I started drafting a reply that I was hoping maybe the Catholic thing would run, but Robert Royal, who's a very, very nice man, said, "Hey, we're just backlogged. We can't." So I'm going to address him a couple of these right now. He says, "Still, why turn away from the decisive moral point that should govern the judgment?" He's critiquing Alito in Dobbs, and I like what a combination of what both of you just said, John and Ron. It's like he's not actually turning away from moral reasoning in several spots. I was going to get it out chapter and verse, but he's just being bound by what his job is, interpreting what the Constitution requires. The Constitution does not require automaton citizens to reason amorally. The Constitution presumes moral citizens. The job, though, what so underwhelmed Archives is the fact that Alito just stayed within his lane as a judge to interpret what the Constitution requires. But there's all kinds of really good moral reasoning in the decision. So he asked that. He says, well, he wanted more moral judgment than the role of a judge, a justice allows. You know, the role of the legislature is to make the laws. The role of the judiciary is to interpret the laws. The role of the executive is to enforce the laws. It's that simple. Stay in your lanes, what we call horizontal federalism. In another place, he says, in other words, at every point in the draft opinion, there's a move to turn away from the more compelling moral argument that he could have used in hard brackets. But all this seems evidently done with the purpose of softening the moral edges of the argument, end quote. And then he says, okay, so I kind of get it. He also says in another spot, this is, I guess, where there's the most conceptual connection to what we were talking about before. He writes the following. I want to get your guys' response to this. I'm going to give my response to it. I'm just going to read what part of what I drafted that I probably won't publish now because the Catholic thing was backlogged. He writes, this right to abortion will remain secure for abortion supporters, at least in the states where they wish to live. This gets us back to blue state, red state. But of course, when people came out in pro-life marches in the worst weather in Washington, they never thought that they were arguing for a license to keep engaging in that killing or on a massive scale, so long as it was done in blue states, end quote. All right. Now, I found this, I don't want to say disingenuous. I just found it misleading. Okay. Here's how I would respond. Of course, to say that the people that showed up for pro-life marches were actually engaging in, they were arguing for continued engagement in abortion type murder is really wrong, right? It vastly misrepresents what the pro-life or anti-abortion marchers march for, which is namely to compel the reminder that in this conglomerated country of 50 different sovereign peoples, we are a country of a compact between 50 peoples, 50 states. The principle of subsidiarity imperiously recommends against what Pius XI calls a grave evil of interference by one people in the police power of another. Now, I'm not saying that if there is some one and done stroke of the pen to get rid of abortion by whatever, a judge or a president, I wouldn't support it. I would at this point, but I'll have to explain why in a second. It's only because subsidiarity has been so squashed. Hadley Arcus forgets or overlooks, this is my main point, I want you guys to respond to this. He forgets or overlooks that in America, that police power, the power explicitly to regulate a state's health, safety, welfare, morals, that's the big one, or security, has always resided in individual states, not in the national government. Individual states get that police power from the 10th Amendment, the power to legislate morality. People accuse me of being libertarian. Only at the federal level. I'm not. Federal level, all they're allowed to do is their Article 1, Section 8 powers, which are very unsexy things like coining money. They're not allowed to be telling us how to live at the federal level. At the state level, they are. They have the police power to, regulate health, safety, welfare, morals, security. So I'm not a libertarian at the level of state law, sexy legislation that involves the way we really live. That should be coming from the state legislatures, which can differ state to state. That's just the theory of America. That's the Constitution. Arkes also forget, and this is my main point. Sorry to go on. Arkes forgets or overlooks also, big point, that Roe jurisprudence was predictably, it's from 1868, was predictably based upon Lincoln's dark legacy, the 14th Amendment, and the 14th Amendment's almost total subversion of American subsidiarity. A reader of Arkes would never know what the 14th Amendment is. That's right. Let me state this more clearly. Anti-abortion Hadley Arkes, great hero for the movement, regularly extols, and I think he does twice in this article, the 14th Amendment, which jurisprudence is the very legal theory that made it illegal for the states to make abortion illegal. People out there might not know this, but when a case is heard, it's not just nine justices in this case, deciding what they like. There has to be a legal theory. The 14th Amendment is what made it illegal for states to make abortion illegal. It also made it illegal for the individual states to illegalize porn, contraception, right, in Griswold v. Connecticut, sodomy, and gay marriage. So it's now nationalized. By nationalized, I mean illegal for it to be illegal in any of the 50 states. Abortion can't be illegal. Porn, contraception, sodomy, gay marriage, that all comes from the 14th Amendment that is so extolled by Arkes. What is going on here? Of course, Arkes doesn't want subsidiarity subverted. The 14th Amendment represents the subversion of subsidiarity in pretty naked terms. He doesn't want subsidiarity subverted in order to force abortion to be legal. That would be unfair to him. He wants it subverted in order to make it illegal. And of course, here he and I find ourselves the very nearest ideologically. Look, if you could do it, I'd be tempted to do it. I want to play you in a second a funny quote that I think represents very aptly what it is to try to use the 14th Amendment or to try to use some battering ram against subsidiarity for friends of God. I don't think this can really happen, but if you could defeat subsidiarity, which Pius XI says in Quadragesimo Anno, should never happen. Bad stuff will always arise. Then it would be kind of like using the One Ring of power against Sauron, right? So the question arises, what difference does it make whether we eviscerate abortion the subsidiarian way, which is what I'm going to talk about a little bit at the end, or the opposite? The Catholic answer is, it makes all the difference in the world. You actually, because it's wired into nature, you actually cannot use some anti-subsidiarity thing, means, mechanism, like the 14th Amendment to do good. All that will come from taking away the states' rights by the federal government, which the 14th Amendment did to legislate on the police power, all that will come from it is you go from slavery, horrible bad, horrible evil, to worse, abortion, horrible evil. This is like a scene from Fellowship of the Ring at the Council of Elrond. Let me play you guys this. Think the Ring is 14th Amendment. Boromir of Gondor is like Hadley Arkes in this case. I guess I'm like Aragorn. That's just an accident, though. Listen to this.
It is a gift to the foes of Mordor. Why not use this ring? Long has my father, the steward of Gondor, kept the forces of Mordor at bay. By the blood of our people are your lands kept safe. draw the weapon of the enemy. Let us use it against him.
You cannot wield it. None of us can. The One Ring answers to Sauron alone. It has no other master.
So you see, okay, so Ron, you respond to this. You see, you can't use, this is my theory, you can't use something that the popes and the greatest Catholic thinkers and the church has taught us is evil, centralized power, global. It's basically globalism, right? To have Washington, D.C. telling people in Honolulu 5,000 miles away how to live morally. All they can do is Article 1, Section 8 stuff. You have them trying to assert a police power, even to do good the way Arceus wants. That's like trying to use the Ring of Power. What do you say?
Well, I think that we need to look at the structure of the Bill of Rights and the 14th Amendment, and in essence, I think, at least to counter your argument a little bit, I'll say that the Bill of Rights put into place shortly after the Constitution was adopted was understood and seemed to work fine. It gave very specific limitations on the federal government. However, that allowed slavery to go ahead because the states were not regulated by the Constitution the way the federal government was. So after the Civil War, we get the Civil War amendments, 13th, 14th, 15th Amendment, the 14th Amendment, which says states cannot deprive individuals of due process or equal protection of the law. For 100 years, that was understood as very minimal limitation. I mean, it's still only slavery for sure, but in terms of our criminal laws in particular, the kind of stuff you're talking about, it only said states had to provide those things that are inherent in the very concept of justice. So it provided fairly minimal restrictions on states. That was still left overwhelmingly to the states, with a few little touches here and there. Then it's the 1960s, and I'm talking about this criminal procedure, which I've got a stack of exams I have to grade right behind me here. But in criminal procedure, in the 1960s, you get the Warren Court, the same Earl Warren Court that solved the Kennedy assassination once and for all. Same Earl Warren. The Warren Court made everything incorporated. That they adopted a new way of evaluating the 14th Amendment, and it said, is this fundamental to the American scheme of justice? They went from a very limited thing to hey, we're a great big thing like you're talking about. And so in DC, we can make laws for Hawaii. And that's where I think the focus should be. What happened in the 1960s when we reinterpreted the 14th Amendment instead of how we used it for the first 100 years of its existence. So I do think you've got a point that when you federalize everything and you do strip away subsidiarity and you don't allow states and localities to make the laws at the level that affects us most directly, where when I have a problem, I can go down the street to the alderman and say, hey, we need to fix this, and they'll take care of it. I mean, I can do that for things that are decided locally, but when they're all decided in DC, it's really hard for me to have any kind of voice. And I do think that I think you have a point in what you're saying. On the other hand, I'm also with you. I think I'd sign on if we could do away with abortion. I probably would sign on to this one. Since we live in the world where the 14th Amendment is understood the way it's been understood since the 1960s.
What do you say, John?
If I can jump in, Tim, very stimulating challenge you've raised. Excellent. This is what makes law school so much fun. We can have these discussions all the time. I had a couple reactions to what you said. First, on the 14th Amendment, I'm not a scholar of the 14th Amendment. I think I echo what Ron was getting at, which is the 14th Amendment, I think, has been misinterpreted. And there are scholars, Randy Barnett and Chris Green at Mississippi, and a number of scholars have been working diligently to correct those misinterpretations. So, but that is the world we live in, where the 14th Amendment has been interpreted beyond where apparently its drafters intended. On a broader point, I think there's two things you touched on, Tim, that are both true and so important. With regard to subsidiarity, why is it that the popes, our church, the Catholic social doctrine of the church is an undiscovered treasure as far as I'm concerned. Your book about the Catholic nature of our founding, Tim, was an eye-opener on that. It's really an undiscovered treasure. Why do the popes emphasize subsidiarity? Is it because of politics? No. It's because they embrace the Aristotelian point that human beings are born with abilities that we need to develop. And it's up to us living in community to develop our own and each other's God-given talents. And how do we do that? We don't do it by the government telling us what to do and what not to do. We do it through developing habits and through our own moral reasoning. So subsidiarity is not just a political point, it's a moral point.
Yes.
A higher authority takes away from me my ability to develop myself, then they are committing a grave moral harm against me.
Yes.
And the brilliance of our founders, with one or two exceptions, were not Catholics, was that they understood that philosophical point. And so grave moral problem with Roe number one is that it took away from the local governments, from the localities closest to the people, the ability to do moral reasoning. And therefore have done a moral harm to the American people. I'll state it that broadly. Number two, and it's related, and you touched on this, Tim, is you use the great expression, stay in their lanes. The founders never intended judges to be our moral solons on a hill making moral decisions for us. 5 people in robes telling us what is moral and what is not moral. That would be preposterous to the founders. Rather, and you touched on this, the idea was, and I would say still should be, and still is, that the people are responsible for moral reasoning. How do we do it? Well, in Athens, which at the time was the size of Oxford, Mississippi, you really could get all the people together and they could reason together. In our system, we do it through the Republican form of government. This is how subsidiarity then dovetails with the idea that moral reasoning should come from our legislatures, which in our system, for better or worse, our legislatures are the voice of the people, not judges. And so there's sort of two power divisions here that we really should be clear about, and you've touched on it. Number one, judges are not our moral arbiters. Morality should come from the people. And that dovetails with the idea of subsidiarity. How do we best obtain the moral reasoning and moral judgment of the people? Well, at the level closest to the people. So in a way, again, maybe I'm being idealistic, by kicking this back to the states, we're embarking on another great political and I would say moral experiment, and see, to paraphrase Franklin, whether we are worthy of it. All right, we now have the opportunity in our states closest to the people to express the moral will of the American people. No more 5 justices means what's moral in our country, at least on this issue. I'm excited about the possibility. And I would say finally with Hadley Arkes, who is brilliant, and I read the Claremont Review pretty religiously as well, Tim. Doesn't surprise me that you do as well. By condemning or criticizing Alito for, I'm going to put it strongly, for punting on the moral issue, he's embracing the idea of these Supreme Court justices being our platonic guardians. In other words, he's embracing one of the grave errors of Roe in cases like it.
Yes.
And I think that's just a mistake.
But okay, two things in response, and then we'll move on, because I do have a way for reconciling giving this back to the states and not having as countrymen people that embrace the opposite res publica, which I want to conclude with. But to me, the 14th Amendment, even its original conception for the first 100 years, until you got the Warren Court, the reintroduction of something called substantive due process, where you started getting privacy made up and found after 100 years, from 1868 to 1968, that's when the 14th Amendment started being used really evilly. But I say of the 14th Amendment, Ron and John, exactly, there's nothing else I say this about under the sun, exactly what I say about sacrosanctum concilium. I say, yes, actually, no, it's not as philosophically sound on its face in its four corners as sacrosanctum concilium. Sacrosanctum concilium, which is the Vatican II document that gave us the new mass, is technically sound on its face, but they knew how they were going to apply it at the time. How they're going to misapply its vagaries. 14th Amendment isn't quite so sound, but it's similar. I mean, it's at least good because you can get people to go along with it because they say slavery is really wrong, which it is. Well, it's not as wrong as abortion. And I'm willing to give this to the states on abortion. The fundamental idea of America is that it's the 50 sovereign states or the 13 sovereign states. They do all the moral reasoning. That is America. And you don't come over at the top at them, no matter how crazy their legislation is in one of the states. That was America. The combo consolidated and confederated government that Madison claims to be describing in Federalist 10 and 39 and 51, that the anti-federalists were really, really serious about it. So I say the 14th Amendment is like that, where the problems were baked in at the time because, one, they didn't really have the legal theory. I say, look, are we comfortable with the theory of America? It seems like when people say, well, because of slavery, no, we had to breach subsidiarity. John, one of the best parts of the great thing you just said is subsidiarity is not just a legal theory put forward by the Catholic Church. It's not even just a moral theory put forward by the Catholic Church. It is part of our ontology. It's part of the fabric of being.
That's
that
right.
You cannot get around it. If there's one state in this consolidated, confederated combo called the United States, that's like the 51st state, murderland. The original theory of America on subsidiarity is like, well, that's their republic. The individual states is really the republic. This is more like Congress is a treaty gov term. Federal is a treaty gov term. It's more like we're just a league of nations. So we're getting into really philosophical stuff. On the other hand, I think you were saying something similar. I might be going a little further. What's most offensive about Archias's view is that like the abortion yielding 14th Amendment, he paradoxically supports his attempt to nationalize top-down morals from the sleaziest state in the Union, cesspool on the Potomac, Washington, D.C., informs a paper-thin veil for the clear human inability, perfectly inability to galvanize continent-wide moral consensus 300 million strong. And so that's the very point Archias sidesteps here. And all of those Claremont Review of Books guys, they're all Straussians. They all want a big government conservatism. There's no such thing. And Pius XI furnishes us with the reason why there's no such thing as big government conservatism. This will always eventuate. This is not an accident. That from the 14th Amendment, which was the big government's central way to deal with a moral problem that should have been dealt with by the states, hopefully slavery was gotten rid of by each of the states. Fed has nothing to say on that matter. There's no legal or moral theory to justify them doing it. Instead of that, they all act surprised that an even graver evil than slavery arose out of the 14th Amendment, abortion. And in his hurry to canonize the 14th Amendment's anti-subsidiarity, I would say Archies, sidesteps the point that everyone, yours, my, everyone's virtually and morally representative republic is our state, not the union. The union is a leviathan, 1/3 the size of the landmass of the third largest continent on the globe and 60% of its population. In other words, you are actually being virtually represented if you're in a red state, and they make abortion illegal, even if across the border in, I don't know, where might they have it legal in a month? Where might abortion still be legal that's close enough to here? I guess the closest place is like Colorado or something.
Illinois.
That's okay. Yeah, take your pick. Illinois, Colorado. That's kind of like China having forced abortion. It's not. I'm sad for all the Chinese baby and the Illinois babies that are aborted. I pray for them. I'd love to end it, but if we look at our res publica as our state, which is the idea behind America, then all of a sudden we are like, well, we are being represented. We're not in moral league with these people. If we zoom out and we take the more 1868 view of what a union is, then I'd say the solution is not to try to breach subsidiarity. I'd say the solution is, if I'm feeling morally accountable for what people in the state of Illinois are doing, then we need to dissolve the political band between us. And that's so in a sense, Arkis is saying Alito's draft opinion is good, but he's not going far enough. I'm saying Arkis's will is good, but it too is an attempt at a shortcut for what really needs to happen. In a 300 million person republic, a contradiction in terms, 150 million of them love abortion, love child murder. I'd say he's the one taking the shortcut. Arkis is. What needs to happen is we need to divide this thing up. Mommy and daddy don't love each other anymore. What do you guys say?
Well, I take your point, and I go back to stuff John and I have written on with the International Criminal Court, where when you create a structure, you don't know who's going to control it later on. And I think that's sort of what the problem is you're pointing to, and slightly different angle perhaps than I think of it as. But one of the reasons we've been very suspect of the International Criminal Court was, someday some other people with very different values than we may have from the United States take over, and when they have control, they have control. And that's sort of what happened already, and sometimes with the United States, and that's what you're saying. I think you can have a structure that recognizes subsidiarity and allows for much more local decision making. But when you have a structure that encompasses everything, that's why the structure is so important. Which, by the way, is one of the reasons that so many, mainly Republicans, I guess, but people are concerned about the leak from the Supreme Court. It damages the structure. When the structure has end results and consequences that can be very significant, even if we don't see them today. If we can no longer trust our Supreme Court to handle things, that's going to impact things in the future. And I think if we put a structure in place where we are able to, and that's your argument against 14th Amendment, I think we can operate within a 14th Amendment, but I get your point. So I'm not buying the divorce language yet. Again, I live in Mississippi with you. We tried it once. It didn't go well.
I would just very quickly, just to build on what Ron was saying. Tim, what I hear you saying, and it's perfectly reasonable looking at history, that, and these are my words, not yours, the founders built this magnificent structure, and it failed us on a grave moral issue, slavery. And that led to bloodshed and almost the dissolution of the Union. And now we have another grave moral issue. And is sending that issue back to the states, which was the faith that the founders had before the Civil War about how we work through moral issues, will it be the same result? Will it lead to either actual bloodshed or the dissolution of the Union? In other words, the structure let us down before as a political body on a grave moral issue. Do we run the same risk here? That's the very poignant question that I hear you raising. And my only response to that is that, well, it has failed us once. I still have faith in the system, and I'm not sure what the alternative is. So I want to embark on the experiment and have our system, as Ron was just saying, have our system work through the structure that the founders built, but recognizing the risk you're pointing out, Tim, it may not work. It may end up leading to the divorce. But I'm willing to go through the exercise, through the experiment. I have, and I'm not saying you don't, Tim, I know you do, but I have great faith in the American people. And more importantly, I have great faith in, as I said earlier, the truth always wins. Even if that process and the truth being vindicated is a bloody and painful one, and certainly no one hopes for that. Anyway, that's my response to you. I think you and I see things pretty much the same way. I'm just betting the other side of the line from you, Tim, is the way I look at it.
Yeah, yeah. It sounds like we're all pretty close to one mind. Dig this little consolation. If I had the fancy, if I can make this a T-chart on the screen for people to see, which I can do this stuff when it's just a solo vid, but then I would look, do the South in 1861. That would be one side of the T-chart. The South in 2022. So when it came to the Civil War then, and a theoretical great divorce now in 2022, the South represents the good guys here in 2022. I would say the South in 1861 had, first bullet point, the wrong issue, slavery, right? They were wrong on slavery from a moral perspective, but they were right on their philosophy of government and nature and scope of government. They had the right philosophy and scope of government, even though they had the wrong issue. And thirdly, they were the initiator, right? Well, actually, no. Kevin R.C. Gutzman's going to take me to toll. They're taken to be the initiator in that conflict of the Civil War, by and large. I don't think they actually were, but they were much closer to the initiator anyway. Look at the South now. Now, in abortion is the new slavery. It's more important. There's a conceptual connection. It grew out of the 14th Amendment, which was a bad Band-Aid the federal government, breaching subsidiarity, tried to put on the slavery issue. Federal government doesn't have the authority to do that. So now it's abortion, and the South represents the right issue, the right moral issue, right? We're on the right side of it. And we have the right philosophy of government, the right scope of government, subsidiarity, just as the South had in 1861. And in this case, this is the really unique opportunity. Thirdly, the South would not be, the red states would not be taken to be the initiators of a civil war. It would be the blue states. So all I'm saying is, like Damian Lillard, bye-bye, let them go. Let them go. This is so much better. This, unlike in 1861, where there had to be bloodshed, I'm saying if these blue staters really have, they're this satanic, they're this Luciferian, it means this much to them to be able to slaughter their babies, for the mother to be able to slaughter her baby. Let them go, and it's perfect. So this is in a new and improved 1861, where we're on the right moral issue and we're not the initiator. Plus, we retain that we have the right philosophy and scope of government. What do you guys each say to that? Just quickly.
Because Alito did not take the Arcus line, they don't need to break away. They can allow abortion. They don't need the divorce to do that.
But they're calling for it all the same. They're calling for it in the streets, Ron. I'm just saying that. Just from having it taken away in 26 states or so, they are saying, we're going to do our blue states and we're going to leave. It doesn't quite make sense. Nothing they say does. But I'm saying if they are, good. What do you say, John?
Well, I don't take seriously the talk of the blue states of the divorce. That's my main reaction. But if I'm not, I guess the question comes down: are we willing to fight another civil war, to keep the union together over this issue. And what I want to do is to preserve and to continue living in states that have a proper moral compass. I mean, that's my entire reaction. So as long as I can do that, if these other states, I just can't fathom celebrating killing babies. I just can't fathom the ethos of that. I don't understand it. So as long as I can live in a place where that is not the prevailing ethos, then I'm happy. And I'm really not sure, you ask my personal opinion, I'm not really willing to arm up to keep people in a union with me that are part of that ethos. But I also don't think it's going to come to that.
I wish it would. Yeah, I can't fathom that either.
I don't wish it would. Just if anyone takes a soundbite, I don't wish it would come to that. I'm sorry, Tim, to interrupt.
Yeah. No, you guys are clear. You don't wish it would come to that. I don't want fighting. I just want a peaceable divorce. Divide those assets equitably. The government, whatever, however it would work. Like St. Augustine reminds us, government is not secula seculorum, right? This is city of man, not city of God. Right. It's government's fall, and breaking it up in an amicable way would be awesome. I can't imagine celebrating abortion. I also can't imagine, it's right 50-50. Half the people in this country love abortion. They love it. I can't imagine calling them my countrymen, and I don't. And I really mean this. I'm not trying to be maudlin or melodramatic. I just don't want to be, we're not in a res publica. We don't share. They are the opposite. We are Christians, Catholic Christians with a small scope of government. They are worshipers of everything that we hold the opposite. They're not my countrymen. So
it was probably 25 years ago. Czarnetzky said something that I scoffed at him at the time, but I think it's proven true. It's maybe the only thing that he's had truth for that long, but he said the left is motivated by the desire for sexual license, basically, at any time and with anyone you want. And so, and abortion fits right in with that, as to so many of the other sort of movements we see. So I'm not sure. I'm not sure it's fair to say they love abortion. They love what abortion provides, and that is the ability of complete sexual freedom.
Yeah, I totally agree with John 25 years ago, you now. And the only thing we disagree about, I do want to just make this clear, because both of you guys hold big, important positions at law schools, is so I alone on this program have expressed, look, I think the great divorce is a good thing. Both Ron and John were saying, though we agree about all the abortion stuff, most of the 14th Amendment stuff, no, we want to continue to run the experiment a little longer. I want that clear, so no one's out there saying, "Oh, Ron and John said something extreme trying to get them." That's utter law, right? You guys disagreed with me there. I want to make that clear.
I just want to say Amber Heard and Johnny Depp show that there's no such thing as an amicable divorce.
Yeah. When people said
I've been following that trial for fun.
Yeah. If he got up on the wrong side of the bed grouchy one morning, now we know why, right? She soiled his side of the bed. What a woman. Okay. Well, final question. I promise I won't even say anything here. I promised a great friend of the show that I would ask you guys, will Dobbs preempt, to borrow a legislative metaphor, will Dobbs's judicial language preempt the Biden Congress's HR 3755 if it passes? It's passed one of the houses, but I say I don't think it can. I don't think you can codify Roe from a national legislature just because it's the legislature, not the judiciary. I don't think you can codify it nationally if Dobbs stands for the proposition that abortion is going back to the states. What do you guys say?
Well, you and I exchanged a discussion on this, and I think we shouldn't underestimate how clever the judicial and lawyerly minds are on the other side. Yeah. I think, to quote the great philosophical film, The Godfather, difficult but not impossible. All right, a Hyman Roth scene. Difficult but not impossible. After we spoke, Tim, I took a look just very briefly. The bill itself, the House bill, cites the first clause of Article 1, Section 8 as the jurisdictional or the power or the authority for Congress to propose that bill. Well, just to tell your audience that might not be lawyers, the first clause of Article 1, Section 8 is the general welfare clause. So we have Congress, the proponents of this bill, resurrecting a theory of constitutional law that the Supreme Court has rejected, but they're not going to stop. They never stop. That Congress can pass anything that's in the general welfare. And so that's interesting by itself. There's going to be presumably an argument that this bill, Congress has this power to pass, to codify Roe because of the general welfare clause. Well, that means, just for the non-lawyers that might be listening, that means Congress has the power to do anything, right? That means they can pass any bill, regardless of what the founders meant about limited federal government. But even if that doesn't work, later in the bill, and I just skimmed it, I didn't read it carefully, they cite several other reasons you and I exchanged, and the one that I think they would rely on most strongly is the interstate commerce clause. It's in there, Tim. I don't know if you spotted it when you looked through it.
Yeah.
Now, that type of reasoning, that I predict that would be litigated in the courts. That type of reasoning has only failed once, as far as I know. In other words, the Supreme Court has only struck down really one important interstate commerce regulation in recent history as not really being interstate commerce. And that was, I think it was called the Violence Against Women Act about 30 years ago, that sought to regulate guns as an interstate commerce issue. The Supreme Court said in that case, look, guns travel in interstate commerce, but this is a health and welfare regulation. It's not an interstate commerce regulation. But anyway, I'm getting a little too deep in the weeds. Let's just back up. Can they do it? Well, let's not underestimate. They're going to try. General welfare clause, interstate commerce clause, some type of exotic, or to me exotic, but perhaps not to them, exotic theory under the 14th Amendment, privileges and immunities clause or something like that. There are routes that the proponents of this bill can take, I would predict, that would lead to litigation in the courts. In other words, wouldn't just be dismissed out of hand. So to me, the question isn't, do they have the power to do it theoretically? I'll bet you all of us would agree on all of those theories and whether they should work. The question is, they pass the bill, will a federal judge enjoin it out of hand because Congress had no power to do it? I would say no. This is going to be a live issue. I'm interested in what Ron had to say.
Yeah, even if we'll add a little gloss for Ron's take at this. Even if these 5 justices hopefully are a little bit pissed off, I'd be a lot pissed off because they're in danger now, which is the very point of the leak. Oh, why can't they be like, oh, you want to play hardball, eh? Well, now we're going to change the language. We're going to tighten up the language. We're going to broaden the language a little bit such that this just fully defederalizes Roe versus Wade abortion rights. They can, this is where the draftsmanship of the opinion matters a great deal. What counts as dicta and what counts as black letter law, right? Can't they kind of play defense preemptively against 3755, Ron, on the cusp of what John just said?
But I think you had to know, if you're going to make this kind of a change, if you're Alito and you're drafting this opinion, you had to understand, he's a brilliant man. He knew that there would be pushback. I don't think the leak provided him any particular new insight to that. So he had to be, if he was trying to preempt a legislative response at the federal level, he would have done it already. And so I'm not sure there's a lot he would do because of this. The thing about getting through legislation, the question I think would be the Senate, whether they can, the so-called filibuster, whether they can get the legislation out for a vote. There may be sufficient motivation to break through that procedural requirement. But I think that's where there's an issue. They got to get this done, presumably. Well, we used to assume that we were going to have a Republican wave coming through in November. I don't know what this does to the election forecasts now, because presumably this motivates the left significantly. But I agree with John that I think the legislation, if it gets through, and you're going to have enough, certainly House members, and the president said he signed it, I think, and if we get caught up in litigation, question to me is whether there's a block in the Senate some way to keep it from really coming for a vote on the floor.
Wow. Well, we're agreeing that the political capital on the other side is shocking. It's shocking how this is their sacrament, the sacrament of child murder. And yeah, I don't know what's going to happen in the midterms. I don't know what's going to happen in the decision Dobbs itself, but you guys have furnished for us a really good look at what some of the ins and the outs mean. And I'm excited that now you've both been on the show. I'd like to bring you back for legal questions. I really have enjoyed talking to both Ron and John. I talk to you guys behind the scenes, but it's fun talking to you on the live airwaves. So thanks for joining today.
Thanks, Tim. It's been a real privilege and honor. Thank you.
Yeah, very much. I appreciate it too.
Okay, well, I'll talk to you guys by text soon. Thanks a million. Everyone out there, like this video, subscribe, click the notification bell, support this program on Patreon, timothyjgordon.com. We're going to be doing for patrons a summer reading club. I am reading, I think, aside from Lord of the Rings, the second greatest Catholic novel of the 20th century, Windswept House. I'm doing that in reading club. Tonight, we have our third meeting, but not on my channel, on the Quite Frankly channel. So go there if you're part of this reading club. But I'm going to, as soon as we finish this in 4 weeks, I'm going to start a patrons only for all level of patron, even the lowest level of patron, a reading club of the first greatest non-Lord of the Rings Catholic novel of the 20th century, written the year after Windswept House. It's called Father Elijah by Michael O'Brien. Both these books are incredibly predictive in their prognostications of what would happen in the Francis pontificate. Unbelievable stuff. Father Elijah's just got a little more action. So that's one enhanced benefit that all patrons will get if you join up today. Also, as we've talked till we're, no pun intended, blue in the face, the red state, blue state issue has never been more important. I've been telling you guys this for almost 4 years. Now you get it. Get the hell out of your blue states. Get to a red state. That's your real republic. Realestateforlife.org will help you do it. I am not joking. Get out before the midterm elections. God bless you all. Deus Volt, God be with us. Thanks, Ron and John.